Nsem-Pii TV nie. Emma akwa babiem edeba Nsem-Pii TV platform yi eso. Now, the Economic and Financial Division of the Accra High Court etnase last week enyema munya no nti court proceedings aneke was to us no entimi amaso for certain reasons. Legal vacation enche ebeshase from 31st July right through to October and sana court ebesen resume asitina enunti no the trial judge Justice Efiasewa Asaributwe say sanity dia this week the Republic versus Kesa Atoforsen and Richard Jakpa. Monday court betinaso, Tuesday court betinaso, Wednesday court betinase na say tiasem. Then the court etnase na Richard Jakpa his subpoenaed witnesses and emubako ebepimo court. Originally lenka was saying kemunu neba, but as usual omo delay tactics ni omo niam bia omo ya Tembia and Justice Efiasa was Butchi at Yomo they repeated the same thing. Now so the Chief of Defense Staff, Lieutenant General Pompey every PMO ever court. Now in court, in him say per proceedings in the Attorney General objection or raise ye say oh na wakako supina a Chief of Defense Staff, Lieutenant General Pompey say omrano media dance amount. So now he's acting as your witness. Namremuno Attorney General is opposing say nipa also acting as a witness. Di enti na odna ba begina adaka mu na all two questions man na to say the owner all cross examine nipa no. The cross examination should rather be done by the Attorney General and not lawyers for Richard Jakpa. That is Tadio sorry. So when court proceedings here be ya chiremu ube hu say Tadio sorry mum a no Richard Jakpa lawyer a no so pina CDS Chief of Defense Staff Lieutenant General Pompey so media dance here no no mum and cross examine no. DNT no yes I did because last 2 weeks every court equassisna you say a letter be a beto concerning how Richard Jakpa was removed from the Ghana Armed Forces was confirmed. Yes, was confirmed. Say ampa he was discharged not honorably. Yeah, you know paso and the free Ghana Armed Forces name. There were issues with regards to the conduct as a soldier and also other jumedi bi a odi won chen enu nti na yi ni free afiase eno enenne tadio sorry instead say obebusa questions ama Chief of Defense Staff akan semwa ebeko into the favor of the client, that is the third accused Richard Jakpa onu mum ene pese or cross examine Chief of Defense Staff na open another sembi and they counter the already established bad record of Richard Jakpa with regards to how he found so a free the Ghana Armed Forces. Na any can ever court because the Attorney General Godfrey Yabonda me ampene amana nyesa. Yenhwe the live footage said the sadi we ACC and ever court.
We have been very worried about the manner in which my friend is conducting his evidence in chief. But it is supposed to be evidence in chief. You supply the witness, he is your witness. And you actually asked him to introduce himself in a manner akin to evidence in chief. You are leading him in the chief. And then you ask him questions as if you are cross-examining. There are a lot of leading questions that have been asked so far. And I think it's becoming one to win. He's leading a witness, and I think it's not proper.
Let me just answer him so that my lady will take the position. First of all,
so far. And I think it's becoming one to win. He's leading a witness, and I think it's not proper.
Let me just answer him so that my lady will take the position. First of all, these are leading questions are allowed in basic. Where the matter is already in evidence, it is purely introductory, or a matter that is not in dispute. It's clearly allowed in examination. Hey, my lady, I'm like the Attorney General, I'm getting worried about the number of times in which I have to be told how the issue of my tone, all of that. So this is a quite straightforward matter that once it is already in evidence, there's no need. There's no need for it. And two, there's a second.
Let me see the document.
Yeah.
And then
no, let me add the second reason.
Let me see the document.
Okay, I wanted to give you the second reason why that objection is not enough.
Let me see the document.
I wanted to demonstrate
because I don't even know what to do about
it. It is regulations of the armed forces.
What is the part about
Exhibit BF3. You see, there's an attachment.
BF3?
Yes. They'll stand there together.
Part about voluntary retirement. Where is the part?
That's true. I actually introduced that.
Hold on.
Oh.
See, you explained to me that it has to do with something which is already in evidence.
Yes.
Now, I have not seen the document, so I now say I want to see it. So the last question had to do with the manner in which tenure can terminate in the military.
Yes.
So you raised issues about how they are terminated up until the point relating to
medical benefits.
No, voluntary retirement or compulsory retirement.
Yes, ma'am.
Now, you have also admitted that that is something you just introduced. Yeah?
Yes, ma'am. But that was going to my second answer to the objection.
Okay, which is what?
That the fact that a question is closed doesn't make it leading. So we have three types of questions. One that has in it the answer that is desired. There's also what we call a yes and no question. That one, when it is asked you, you can answer yes or no. And there's what we also call a closed question. It limits you to something that is basic. And this is the Chief of Defense Staff who knows his rules.
No. Please, the Chief of Defense Staff is not there as a lawyer.
No. With all
Hold on.
He's not here as a lawyer, but he's presumed to know it.
Let me write my reading. Yeah?
Oh.
Finish your argument.
Yes, so he's presumed to know his rules. So this one required a yes or no. No, that ignorance of the law. That's our basic principle of which we operate. But besides that, it is a yes and no question that he was required to answer. He could answer yes or no. He answered yes. In fact,
looking at documents that without permission.
Yes, my lady.
Mr. Sorry is to refrain from asking any leading questions on matters which are not yet in evidence or in controversy. If he seeks to elicit information, he is to ask open-ended questions which will engender answers from the witness who is here to give evidence on behalf of A3. That is and has always been the view of evidence. So please, let's go. You know what?
No. So,
Please, give the document. Please, people are disturbing. Sit down. You're doing too many things at once. Please, here's the document.
if you just, we got distracted a little bit. There's a question I think I asked before that. Which one? All right.
Yes.
So, listen, take a look at exhibit BF3.
Can you assist me there to me?
BF3, that's and the attachments that goes with it. I'm referring you to item 1 G. Now, item 1G falls under the column which has to do with cases applicable to misconduct. Is that correct?
Yes, my lady.
Now, specifically, tell the court.
Still, my lady, still. I mean, it's actually suggesting the answer to the witness. You could have asked if I were you. What do you see there?
But it is evidence.
It is not.
It is an evidence.
Please.
But for you to suggest the answer to the
He will
witness.
tell you that he is not you. And then he will start.
But that's fine. He's not me.
Please.
But the rules remain the same.
I have already.
Yes.
You see, I keep saying this and I will repeat it. When it comes to trial by a single judge, the thing that would affect the jury would not affect the judge. I have already told Mr. Sorry what to do. But Mr. Sorry wants to do what he wants to do. I will not do that. I will not engage you. I won't do any such thing. Because Mr. Sorry knows exactly what to do. He teaches the subject. He teaches advocacy. He knows what to do. So please, let's not argue. If he wants to continue, he can. And please, if it is okay, because I have already told him, otherwise, you will raise objections the whole afternoon. Please, you can make a note and comment.
No, but with all respect, my lady, making a note is not sufficient. And it's also not fair to us. But he's breaching the rules in relation to a witness that he has called. And we're just supposed to condone him because he wants to do as he pleases. My lady, with all respect.
I'm not saying I am condoning it because he wants to do as he pleases. I am considering needless waste of time. So let's continue. Mr. Sorry,
I have said that it's an elementary exception to the rule.
You have said it is an elementary exception. I have also ruled on what you say is an elementary exception, but you have decided that because you think it is an elementary exception, you will continue. Okay.
I didn't see that clearly in my lady's ruling. Maybe that's what
I said you are to refrain from asking leading questions of matters which are at all new or in controversy. That's what I wrote.
But this is not in controversy. It's not new. It's in evidence. So I didn't breach the rules. I'm clearly within my lady's ruling.
Will you continue?
I will not. So please tell the court what can be found in item 1G. Which
My lady,
yes.
is written under cases in which applicable. And G says having failed to settle his private debts.
And this 1G you have just read, to which reason for release is it assigned?
My lady, is assigned to misconduct.
Take a look at item 2 and find out, tell the court what cases are applicable to item 2.
My lady, I need clearance. Should I read all items under 2?
Yes.
My lady, reasons for release under item 2.
You can mention them according to the letters, how they distinguish them.
Okay, some of them don't have the letters, so I have to just read.
Very well.
That's why I asked.
Yes, sir, please.
Yes.
Serial 2, that is inefficiency, that is reason for release. And cases in which are applicable, A, through continued lack of application or interest.
Very well.
B, through continued unsatisfactory service. C, unsatisfactory conduct. And if you go to notation on certificate of services,
Very good.
it indicates service terminated.
Service terminated. That's all.
Yes, my lady. And then the last, the special instructions. See articles 15.21 and 15.33. Notice of intended release.
Now, what they say, so go to item 3 and tell the court what notation or certification is applicable to item 3.
Item 3 is honorably released. That is under the notation of certificate of services.
That's the notation. But what reason is assigned to that specific notation?
My lady, item 3 is medically unfit.
Now, apart from item 3, to which the notation honorably released is applicable, can you find honorably released in respect of any of the other reasons?
No, my lady.
Now let's do exhibit here. Here, that is the first one. If you look at exhibit B, the minister writes that the third accused was released from the army on 3 main grounds. Do you see those grounds? So it's BF1. Sorry, it's BF1. BF1, sorry. It gives 3 reasons.
Yes, my lady.
Good. Now, immediately take a look at exhibit BF3, which is coming from the military itself. In paragraph 1, it states specifically the reason for the release. Isn't it?
Yes, my lady.
Are they the same? Are the minister's reasons the same as that assigned by the military for the release of the third accused person.
My lady, the minister writes that I'm providing you with official records.
For Nsem-Pii or no more, now Nsem so it is. Utie now show on my YouTube channel.
Be the first to know Nsem-Pii TV.